After the United States Supreme Court issued a major order denying emergency review to the state's original Second Amendment Preservation Act, the law remained locked down under a sweeping federal injunction. But an explosive new twist has now developed. During those Supreme Court proceedings, the Trump DOJ made explicit promises to the Supreme Court that they would step in and narrow the injunction and protect the state's right to non-enforcement if the Supreme Court denied review. Months have now passed after that, and the DOJ has completely failed to act on that promise. Tired of waiting on the federal government to actually honor its word, state legislators have now moved on to actually introduce a new SAPA 2.0. They are fast-tracking competing frontrunner bills to completely cut off state resources from federal overreach. So in this video, we're going to break down what exactly is going on with the state action and what has happened in response to that Supreme Court denial. Now, before we jump into what is going on with this two-way legislative battle and what happened after the Supreme Court denial, if you want to continue to get these videos going forward, make sure you subscribe to the channel and also turn on all notifications to make sure you never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. So if you're interested, you can check them out using the links down below. And right now, for a limited time, if you use my exclusive code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee. Now, to understand why the SAPA 2.0 issue is such a massive escalation, we have to look at how we actually got here. So essentially back in 2021, Missouri passed its original Second Amendment Preservation Act, and it drew a very clear line in the sand. It declared that the state and local officials could not assist in enforcing federal restrictions that violated the Second Amendment. They also backed up this law with a civil remedy, allowing residents of the state to actually sue local agencies if they cooperated with federal overreach that violated the Second Amendment. The law relied strictly on the established constitutional anti-commandeering doctrine. Predictably, federal authorities immediately sued, and a district court struck down the entire law with a total injunction. Now, in response, Missouri fast-tracked an appeal, and they actually eventually took this to the Supreme Court for the first time, seeking emergency relief. But at that time, the Supreme Court rejected the stay in an 8-1 vote. Only Justice Thomas was in favor of actually keeping the state law in place, and so he dissented from that order. After the lower appellate court officially struck down the merits of the law, Missouri then filed a second petition for review, which the Supreme Court recently also denied. But it's why the Supreme Court denied that final review that has triggered this current explosive standoff. By the time this case reached its final stage, the Trump administration had taken over. While the Trump DOJ still argued against parts of this original SAPA law, they made a massive concession to the Supreme Court. They explicitly admitted that the lower court's total injunction went too far by blocking basic state non-enforcement. The DOJ gave the Supreme Court its word that if review was denied by the court, the federal government would voluntarily step in to narrow the total injunction and restore portions of the SAPA law and allow Missouri potentially to engage in some of this non-enforcement action within the law. Missouri aggressively warned the Supreme Court and the justices not to trust this promise, arguing that it was simply a stall tactic and a way to get the Supreme Court to deny review. However, the Supreme Court ignored that warning, took the DOJ at its word, and denied review to this case. Now, after the Supreme Court denied review to this case, Missouri's worst fears and what they warned about really were actually realized. Months have now passed since Supreme Court order and the denial there, and the Trump DOJ has completely refused to move to lift or narrow that total injunction. They have completely ghosted on their promise that they made to the Supreme Court, and now that original SAPA case has essentially stalled out. But in response to this, Missouri really is not backing down. Because of the federal inaction, the state lawmakers here have officially launched a SAPA 2.0 effort. This isn't just kind of a symbolic gesture, it is actually a full legislative battle with multiple competing bills moving in both the House and the Senate, and they aim to bypass the DOJ entirely. Right now, there are two powerful frontrunner bills which have emerged within the Senate, and they're kind of leading the charge on this SAPA 2.0. The first major bill to watch for is Senate Bill 858. This is kind of being hailed as the true hardline successor of the original SAPA law. SB 858 keeps the core mandate fully intact. Essentially, Missouri officials are completely barred from assisting with federal overreach that violates the Second Amendment. But to make sure local agencies actually comply, it also retains the aggressive enforcement mechanism that made the original law very famous, including heavy civil penalties and severe legal consequences against any local agency or department that cooperates with federal enforcement. This is the unyielding kind of anti-commandeering approach that really is in line with the original SAPA law. However, on the other side of the aisle sits a kind of primary competitor, and that is Senate Bill 955. This bill takes a significantly altered structural approach. Instead of going all in and taking the hardline approach, SB 955 really just softens the blow in some of the restrictions and is essentially allowing more cooperative windows with federal agencies and allowing a little bit more leeway. Critically, it completely removes or severely limits the civil liability concerns that had local law enforcement groups fiercely opposing the original version of SAPA and also opposing the Hardline 2.0 law. Because it protects local police budgets from civil lawsuits, this moderate version is heavily backed by law enforcement associations in the state of Missouri. So this leaves the legislator at a historic crossroads. Lawmakers are currently testing the waters to see which version can command the most political support in the state. The question is, do they pass the hardline SB 858, the anti-commandeering kind of hammer and true successor of the original SAPA law, or do they try to pass the more, compromise-friendly and law enforcement-friendly SB 955 to ensure that it survives future legal challenges and has broader support within the state? The critical difference in SAPA 2.0 and both of these efforts is that both bills clean up the original language that caused lower courts to strike it down originally. Instead of trying to retroactively declare federal laws unconstitutional or invalid within the state's borders, these new bills focus purely on the state's absolute constitutional right to simply say, we are not going to participate in your enforcement of federal laws that violate the Second Amendment. So Missouri is tired of waiting on the DOJ to fulfill those promises that they made to the Supreme Court, and ultimately those promises which led to this case being denied. The legislative battle is now officially on, and whichever bill wins will set the blueprint for states going forward in their own preservation laws, and maybe that other preservation laws that will be adopted in other states. So as soon as either SB 858 or SB 955 clears the final vote, and as we get updates on this, I will let you guys know, or if even potentially there's updates on the original lawsuit, if the DOJ ever fulfills that promise, I will let you guys know. But if you appreciate this type of content and you want to make sure you get this content going forward, make sure you like, comment, subscribe, and turn on all notifications so you make sure you never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.